Are you relaxed, or should I help you to be relaxed?
Yes, please help me to be relaxed.
You were a prosecutor at some stage, were you
Yes.
not? For how long?
Well, I was a prosecutor for about 2 to 3 years.
Regional court, district court, high court?
District court. That's when I started out of university.
Out of university.
Yes.
We have a problem. I've just been to the magistrate court, some of them use Friday for preparation. Some of them are still preparing by 11 a.m. The result is there are far too many cases that are still to be finalized in a number of magistrates court, not necessarily the one I've been to. What is it that needs to be done to address this? If appointed a judge, how would you train magistrates? What advice, if any, or what guidance can you provide to the prosecution if you were to train them?
I think there we should, if I was going to give them any advice, I would adopt a similar approach with the case management, the case flow management that is taking place in the High Court currently. Because you find that in the Magistrates Court, you have cases are not postponed as it is happening in the High Court. In the High Court, you get, in matters, like in criminal matters, you know that a case is going to run for a week or for 2 weeks, and it's definite when it's going to run. Even in civil matters, you get a certificate
Yes.
that this case is trial ready, then, but you don't get that in the magistrates court.
Okay.
I think that is where we should start with the
Okay.
case flow management there.
Well, one of the problems that I've realized is this. There is a tendency to arrest even when arrest could be avoided. The result is over the weekend, far too many people are arrested. On a Friday, Saturday, within 48 hours, they must appear in court. And instead of the magistrate dealing with many cases that have been pending for a long time, they must now be dealing with the postponement of these new cases and the applications for bail. What approach must the police adopt to avoid this this problem of burdening courts with work that does not really have to be there? What advice can you give them?
The bail,
Can they investigate, for instance, without arresting? Or must they arrest before they can investigate?
no, not really. They don't, there are instances where the police can investigate without arresting, because bringing a person under incarceration does not necessarily mean that they will find, they'll be able to investigate thoroughly or properly. And most of the most of the people they arrest sometimes are not even the ones they are supposed to arrest. So I don't think that is the first step they should.
Are you settled, or should I still try to settle you down?
I'm okay now.
You are now settled.
But you can never be 100% settled.
Sure,
to this.
I understand.
Yes,
In 1999, you joined the bar.
yes.
And then you acted as a judge on a number of occasions.
Yes.
What is the longest period you've kept the judgment reserved for?
I've never kept a judgment for more than 3 months.
Not more than 3 months.
No.
Do you have reserved judgments now?
Currently, I have 2 that I picked up last week.
Last week,
Yes.
yes. Would you, in your own ways, like to tell us why you believe you're ready for permanent appointment to the High Court?
I am now ready. I've been an advocate for the past 17 years. And I've been through the ranks of the Justice Department, beginning from being a prosecutor, and I've done a lot of things in the Department of Justice. I have also taught law at Fort Hare part-time. That was to give back to my university. Not because I did not have other things to do. And I have also acted intermittently since 2007. And I think now the knowledge that I've acquired and the manner in which I deal with issues is more mature now than it was before. And also, now I am able to, I'm in a better frame of mind as a person who's practicing law.
Yes.
And also, if one looks at the natural progression of natural progression in my, not in my CV, in what I have done, I have now reached a stage where I feel that I'm ready to
Yes.
serve on the bench.
I noticed that you were involved in a very important case, Tongwane, that ended up in the Constitutional Court. Is that the
Yes.
quality, the good quality work that you're exposed to on a fairly regular basis, or is it once in a while?
Not on a fairly regular basis. Once in a while, you get such cases. Also, the briefing patterns
Yes.
and the fact that I have been acting on and off for a long time now. I've not practiced since 2012, to be exact.
Oh, very well.
Like you go to,
Yes.
and then it's not like quality practice where you get good briefs, not because you are not capable, but because you are not there most of the time.
Okay. JP?
Thank you, CJ. I'm not saying anything about outstanding judgments you have answered, but what I'm keen to know, you observe that there is an objection from the Society of Advocates, the Eastern
Yes.
Cape,
Yes.
and they are quite lengthy in what they are saying. Now, on the other hand, I see that the Bishop Bar is somewhat supportive, and though it has not written much, but it is quite firm in what it is saying. Now, what is the position? Why is there such, from these bodies, such difference? If you know, if you don't know, perhaps you don't know, but if you know, you can offer an explanation. I'm sure we'll be keen to know.
Well, I was in Grahamstown in the past few weeks. If I have to be specific in the complaint that has been lodged, as a human being or as a person, I am not robust in my approach. I don't go about like in that way. It's in me. However, I have delivered or done my work in a way that is beyond reproach, in that the mistakes that I have made are mistakes that are made by anyone. However, in this issue, I have to be very specific. There are two issues that the Eastern Cape is complaining about. The one matter, I did prepare reasons for judgment, and I gave them, and I even brought a copy of that. The Mari matter. The other matter is a matter of contempt of court. And the judge who dealt with that matter before me even wrote a judgment in this regard. And it is a clear contempt of court, and it does not need me to write another judgment. I gave an extempore judgment saying that I agree with the judgment that is before me, and I am convinced by the submissions made by the applicant. And I could see that this person is really in contempt of court, and I granted that order accordingly. There was no need for me to write a judgment in that regard. So those are the two issues. As to whether I am tentative or not, that is the personal judgment of anyone.
Now, in other words, you're aware of these
Yes, I'm aware.
complaints they're objecting to.
Yes.
Now, have you been confronted as a person or as a judge by anybody to say this doesn't appear to be regular or whatever?
No, I've never been confronted by anyone. I would like to say something in that regard. When a judge is in court and gives an order, the parties are free to ask for reasons for that order. And most of the time, a judge will say, I grant this order. If parties want to know the reasons, they can ask for reasons. So it is not something that is not done. I'm aware that that is done.
Last question. I've met a number of judges that have been coming from the course, surgery course, and the aspirant judges training, and most of them were very excited and very thankful that they attended that course, and you were one of them.
Yes.
Is there a reason why this was so different? Not really different as if the others were not good enough, but deserving of you praising the course and so on. Was there anything special about it?
Yes, there is. You know, even as a practitioner, going to those courses, it makes you realize the shortcomings that you have, both in practice, in your practice, and in when you are sitting as a judge. You are taught the correct way of looking at your judgments and writing your judgments and dealing with all the aspects that you deal with when you are in the bench. So it does make your life easier and your work easier. It really does. Before I went to that course, I did not. I'm more effective now than before.
Thank you. Thank you, CJ.
Thank you, JP. MEC?
Thank you again, CJ. Good afternoon, Advocate. In the submission, your response to the questionnaire, the one around the proportion of your litigation work, it would seem you have done 5% of criminal work, and in these two areas, either Mthatha or Port Elizabeth, they are one of areas that are dominant about cases that are of crime, criminal in nature. So isn't this, what would be your take, given that you've done that limited level of work at the criminal level? The second one is, again, the one on the, you were responding that you, on questionnaire number 8, you have any relevant judicial or quasi-judicial experience, and you indicate yes. I'd be interested which areas specifically. And then lastly, CJ, there's a general perception out there that the justice system in South Africa is for the learned and the moneyed. The majority of poor people always have this feeling that this is not for us. And in your own opinion, what do you think needs to be done to turn around this perception? Thank you.
Starting with the first one, thank you, CJ. Starting with the first one, let me see. It is different when you are a practitioner dealing with the criminal law, criminal procedure, or criminal cases, than when you are sitting as a judge. When you are sitting as when you are a practitioner, you have choices. You make choices that you don't do crime or you do crime. But when you are sitting as a judge, you do the work that has been allocated to you without any choices. So I don't have a choice when I'm sitting as a judge. And in our practice, normally, when you start practicing as an advocate, you do legal work, legal aid work, and there you get a lot of criminal exposure. But as you grow in your practice, you graduate to other work, not the criminal. You do less and less of the criminal work there. So that is why you'll see my questionnaire in that fashion, because as a junior senior in my practice, I hardly do criminal work now anymore. But in the bench, you don't have a choice. Then the second one is, please remind me.
It's page 9, number 8 of the questionnaire. The one where you say, yes, have you any relevant judicial or quasi-judicial experience, either as chairman or a member of a commission of inquiry?
Yes, I have.
Yes, and I was interested in saying, for example, this position I was once in this position or I'm not this position.
For example, I have.
If you are able to advocate, if you are able to be direct and answer the question without being unsettled, that would help a lot.
All right. In fact, if you look further, see, there is a response to that question. At page at paragraph number 9, where I've served as a deputy chairperson of the Eastern Cape Liquor Board, where I have I was a peace and justice minister. I was a convener of peace and justice ministries, where I was a director of in the ATP project, and where I was a legal advisor in the Council of Churches. So I've been in that quasi-legal position for a long time, and I was also a board member in the Eastern Cape Gambling Board. So there are, it's covered somehow. And then the last question is
That's not the last question that
No.
you did. Oh,
there is a last question where, oh, was that the last? All right.
The last one, CJ, was about her opinion on changing the perception out there that the judiciary is more for the learned and moneyed. Yeah.
Thank you, CJ. That one is a perception that is going to carry on for a long time. However, as the different organizations and even as practitioners, advocates, we do give time and we take pro bono work, meaning that we represent people without getting money for it. And in our women organizations of women lawyers, we do provide that service. And as individuals, not in a way that is going to be, I don't know how to put it, but we do dispense just legal advice. Also, in the students that we deal with and other organizations, we do alert people to that. So it's not as if people are aware, but it's taking it's going to take longer.
Commissioner Nogesi?
Thank you, Mr. Chair. The last time you were here, you told this commission that Parliament is sovereign.
Sure.
And when your attention was drawn to Section 2 of the Constitution, you said those were semantics. Have you changed your views?
That was the biggest mistake because I was so nervous. The Constitution is supreme. It's the supreme law of the country. It can never change. So it's just that it was a big mistake.
All right. Now, the power of judicial review no longer resides in the common law and the doctrine of ultra vires, but the Constitution
Yes.
itself provides the basis. Can you, just briefly, in your own understanding, explain what must be the approach of the court in circumstances where it review a matter which is excluded under the provision of PAJA, that is under Section 1 GG of PAJA, how it should approach that matter in its review?
Well, the courts are there to uphold the Constitution and the rule of law. But in matters, in review matters, where it is excluded in PAJA, the courts are not, should not take the functions of that functionary first and use their own, if it's possible, unless it is something that is illegal or something that does not, how can I put it? It must be, the courts should not, first of all, if that matter is, it must be a matter that affects the rights of that person in a way that is prejudicial or it is unconstitutional and so forth. Otherwise, the courts are there to refer those matters to the functionaries that were supposed to do the work, not take the work of the functionaries to themselves.
I thought perhaps you would understand that Section 1C of the Constitution.
Commissioner, let me interrupt you. Don't answer for her, just clarify to test her suitability. You can always argue during deliberations. Yes.
Oh, thank you. All right. And the other question is this complaint by the Eastern Cape Bar, where they say in the opposed motion, you merely gave an order without reasons. Is it not that there is a standard, it's just a standard in opposed, where reasons are not given, there must be direction that they can be sought within a particular period?
That is standard. And in this matter, I even said I made an extempore judgment and said this is what was submitted. These are my view in this regard. This is the order that I'm going to give in terms of what was submitted. So that is what I did. And I also mentioned that there is a judgment already that was delivered in this instance, which was the one that was defied. So, like, it was not necessary for me to write another judgment saying these people are in contempt of this judgment.
Thank you, CJ. I have no
Thank you, Commissioner. Commissioner Nyambi?
Thank you. When you responded to JP, you said your approach is not robust. Can you explain maybe so that we can have an understanding of that?
My approach in court is I listen to both parties that are before me, and I take time to respond. And because sometimes when you just respond, especially in court, you are bound, I feel that you are bound to overlook some of the things that we're supposed to look at. And sometimes when people argue before you, you go there, when you have prepared for a matter, you go there with a prima facie view. And when you get there, you get convinced otherwise. Therefore, it's not, it's, for me, that's my view. It's not good to take a robust approach and decide something there and then, even if you have another view. However, for example, in this one, where what they were complaining about, I had read the papers, and I knew that and then this person was in contempt, and he has been in contempt for several times. There was no need for me to think about it and give a decision later on. I don't know whether that is what you...
You were able to clarify the mistake that you made in your previous performance. Do you have any mistake that you can outline to us instead of doing a repetition of what was asked then?
Well, when you are asked questions in a forum like this, you are bound to make mistakes sometimes because it's nerve-wracking to be here. So I don't know what your question is. What are you referring to?
I said you were able to clarify that now you understand that Parliament is not supreme.
Yes.
So I do have the transcript of everything. So
Yes.
instead of repeating that, do you have anything that you have checked that you realize you made a mistake that you like to correct today?
Well, I've not read that that because I know that I was very nervous on that day. So I did not want to dwell on that because it was going to make me more nervous for today.
Thank you, CJ.
Thank you, Commissioner. Commissioner Ndoni?
Thank you, CJ. I wanted to canvass the question on parliamentary supremacy, but it has been covered by Mr. Nekesi. Thank you.
Thank you. Professor Ntlama?
Thank you, CJ. Good afternoon, Advocate Cossie.
Good afternoon.
You are applying for the PE division.
Yes.
Yes, tell us, how is your appointment going to transform that division? If you are given
In that division, I think that I would be an asset. One, the language. I'm able to read and speak 3 languages, Afrikaans, English, and Xhosa. And some of the litigation there is in Afrikaans, and in fact, there it is 50-50, Afrikaans and English. So I'll also be able to deal with most matters without wasting time to have things transcribed and so on and so, I mean, all that. So that's one. Secondly, with the experience that I have, I'll be able to deal with the matters that come before me as I have done now, because I was there for the past, I've acted there last year, and even this time I have been there. I've acted there, and I think that we need more people, especially women, because there are 2 women. And I think we need more women in that division to get the justice system going. Regarding the transformation, as in the inverted commas, if one talks transformation, there are different emphasis on transformation. I don't want to say because I am black, I want to be taken. I think on merit, I deserve to be taken in that court because I am able, and I've carried my work in an acceptable way. And each division has different, the practitioners that practice in that division have a way of doing things, irrespective of what the rules say and so on. In PE, the practitioners there make you want to go and work there. And not because of the type of work, because of the diversity that is required there in that bench, in that court.
And then how is this appointment, if we do get the opportunity, are going to transform the jurisprudence that is going to emanate from that division?
The bulk of the work there, as I said, it's in Afrikaans and in English.
I'm sorry, do you understand the question though? Because I don't understand it. Prof, would you like to clarify it?
My question is, your interpretation of the law, how would it be influenced by various legal systems that are equally recognized in the Constitution, which result in the transformation of the jurisprudence, other than being confined to the common law principles that we have seen emanating from other jurisdictions?
Prof, I'm sorry to, can you rephrase this question so that I'm,
It's simple. King Dalindyebo,
yes.
when he was convicted, both of them. I'm so sorry. Let's put it simple. King Dalindyebo, when he was convicted and sentenced, both the High Court in Amtata and the Supreme Court of Appeal traced the common law principles from 1906, when customary law was never recognized as a legitimate system of law. Yes, when in the new dispensation, the Constitution requires the courts to apply customary law. Yes, so in the king's case, the king was found guilty through the importation of the common law principles. Through the importation of the common law principles, instead of the principles that the king subscribes into, which meant that customary law, they continue to be the baby that is struggling to get out of the bathwater. So in this context, how would you use customary law to influence your legal interpretation to ensure that the jurisprudence that emanates from the courts is inclusive of the various legal systems of the country?
Okay, now I understand. Prof, if you look at my background, I come from a traditional system, from a customary system. And I have, in my legal dealings, applied that system. And I've also been involved in matters. For example, the matter of Clara that I was involved in that time had a bit of that because it concerned the land that was the land that is under chieftaincy. And although PE is you can say it's an urban area, and some of those issues don't arise there, but PE has a lot of blacks, and there is a lot of people who need help in that regard. And also you get, for instance, this last week, there was an urgent application for a burial, for a burial. This person believed that by custom he has to be buried in Kofimbaba. But one of his children wanted him to be buried in PE because that's where he worked and that's where they grew up. So sometimes you get those aspects or those things which one has to apply one's knowledge and one's experiences in them. I don't know whether that answers your question.
Commissioner Mudimele?
Thank you, Chief Justice. Counsel, you say you conflated parliamentary sovereignty with the supremacy of the Constitution last time because you were nervous. Is that not so?
Yes.
Not because you know better now. So in other words, you knew the answers, but because of the occasion and the moment, you gave the type of answers you gave.
Yes, especially that one. That one, everyone knows that the Constitution is the supreme law of the country. It was one of the big ones.
Yeah. I ask the questions. I'm going to ask you another question I'll ask you and see if you know better now or whether the answer you gave then was also as a result of nervousness. The question was, what is the relevance of PAJA, promotion of access to justice?
Promotion of Administrative Justice Act.
My colleague said promotion of Administration of Justice Act.
Pardon?
PAJA. I've got all this assistance from the commissioners.
What is the question?
May I repeat, Chief Justice, without the assistance? You know what PAJA is?
Yes. The
Yes, let's
promotion.
keep it at that level.
Okay.
The question was, what is the relevance of PAJA to the concept or the doctrine of separation of powers? You then gave the following answer. I quote, the separation of powers, it is relevant to the separation of powers in that respect comes to play where the public institution or public bodies deal with the decision that they are made. And in terms of the Constitution, I mean the public bodies, when people are aggrieved by the decisions, the section that should be protected, that it should protect the rights that people have to then dot. So that is how it comes into play, meaning PAJA to the doctrine of separation of powers. The question is, do you still hold that view?
No, definitely that was wrong.
Did you answer in this particular manner because you were nervous or because you now know better?
I know better, and I shouldn't have answered that in that fashion because that is completely wrong.
Thank you, Sir.
Thank you. Commissioner Modise?
Thank you, CJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
You were convicted at the Magistrates Court at the age of 13 with your friends for stealing a handkerchief.
Yes.
How was that resolved? Because the sentence was never carried out. What has happened?
Nothing happened insofar as like I didn't feel like it was something that was, those were the things that were happening at that time when we were growing up. And I did not think that there's something that I should do about it, like having it expunged or anything. I don't know whether that is what you are asking.
What I thought you would tell us was whether or not it was true that you had stolen the handkerchief.
No, I hadn't stolen the handkerchief. But I didn't want to hide it and say I was never arrested for it, because we were arrested as a group and we were all said charges were preferred against us because we were in a bus, in a group of school children in a bus. So that's what happened.
Has this influenced the way you look at juvenile delinquency at all? Or has it influenced the way you look at children who would find themselves under the same circumstances now that you have been an acting judge?
It has, in a way, because sometimes, although now the laws have completely changed and the attitudes of people has changed, but it has, because everyone must be given the benefit of doubt, and no one must be said he is guilty before that has been established. You know, in those days, police would just arrest you and on a say so, charge you without even producing the evidence to that effect.
Thank you, ma'am.
Thank you,
Thank you,
Commissioner. Commissioner Fori?
Thank you, Chief Justice. See, you recently delivered a judgment in the matter of Bumeza Witi versus the Road Accident Fund. That was on the 18th of November, 2015. Do you recall that judgment?
Yes. Commissioner.
In brief, what happened there, the driver of a vehicle lost control, left the road, and the driver was then killed in the process. His wife and children then instituted an action for loss of support against the Road Accident Fund. And you heard the matter. The issue of merits and quantum were separated, and only the issue of merits were before you. Is that correct?
Yes, yes, Commissioner.
Now, what you say in paragraph 7 is what requires to be decided in regard to the merits is whether there was another vehicle involved in the collision. And then you go further and you say in paragraph 24, the issue before court is whether or not there was another vehicle involved in the said collision. So you repeat that. And then again you say, in the circumstances I find in paragraph 25, I find that the plaintiff has succeeded in proving a claim on a balance of probabilities. I conclude, therefore, that there was an unidentified vehicle involving in causing the collision. Is that the only issue to be determined? Whether there was another vehicle or not? An unknown vehicle?
Yes, that on the merits.
Yeah. Now, let's assume there was an unknown vehicle and you find there was one, but the driver of that vehicle drove perfectly correctly and wasn't negligent at all. Would that have influenced your view? Is that not the test? Whether the negligent driving of the unknown driver caused
Yes.
the deceased to lose control over his vehicle? But you
Yes,
say that
Commissioner.
nowhere in your judgment.
That is also an issue that was supposed to have been there.
Yes.
Yes.
Okay, then I won't pursue that. Then you say, in the result I make the following order. The plaintiff's claim succeeds What does that mean in view of the fact that merits and quantum have been separated? What do you understand about that order the plaintiff's claim succeeds?
The plaintiff's claim succeeds. What is the question?
Yeah. Would a prudent order not have been under the circumstances if you found that the unknown driver was negligent and that his negligence caused the deceased to lose control over his vehicle? Would a prudent order not have been that the defendant, being the Road Accident Fund, is liable to compensate the plaintiff for her proven damages?
Yes,
Where's that order?
It's not written here. But however, Mr. Commissioner, that is why I said, when I went on that course that I went to, these were the issues that were clarified to us when you write or when you write judgments. This order, and in this order can the people I gave the order to are entitled to come and say the order is not clear. So there are checks and balances when a judge makes such a mistake. So this is one of those which have to be dealt with in that forum.
Thanks, Ms. Cossie. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Malema.
So those people, when they come back to you, who's going to pay? Because coming to court is very expensive. Who's going to pay?
Pay?
For them to come to court, they must get lawyers and then come back and say this was wrong. And who's going to pay for those lawyers?
Normally, when a judge makes a mistake, the people who, the costs depend on what was happening or what is about to happen. It does not mean that all the matters that come, because in this one, for example, the people are supposed to come and seek for a clarification of the order. They don't have to pay.
Will I be correct to, okay?
I was just going to say, do you understand Commissioner Malema's question? You know, he is not a lawyer, but he's asking a question which should be obvious to a lawyer. They have paid, they have left, the order is not correct. When they come back, must they pay again for the mistake that is not theirs?
No, they can't pay for it.
Who must pay? That's his question.
The mistake will be rectified and no order is to costs.
Ma'am, for them to come to you, they have to go to a lawyer so that they can come back to you. And for them to go to a lawyer, they have to pay the lawyer to come to you.
Mr. Commissioner, the mistake that is contained in this, there are checks and balances. People go and ask for an appeal or for a review, or they come and ask for a clarification of the order if it's not clear.
For the lack of a better way, okay.
And for example, in this instance, this was against the Road Accident Fund, a fund which has enough funds to engage the services of a lawyer. I don't know whether I am answering this.
No,
because
no, no.
there are checks and balances when anyone makes a mistake.
You are making similar mistakes you made the previous time you appeared here. And I don't know, maybe it's becoming uncomfortable again. But for that sake, for the lack of a better word, will I be correct to say this is what can be described as a miscarriage of justice?
No, Mr. Malema, this is not a miscarriage of justice. I'll tell you why. I don't think it's a miscarriage of justice. The order, although it says the plaintiff's claim succeeds, what was the plaintiff claiming? The plaintiff was claiming that he is entitled to the relief he was seeking.
Advocate,
And-
you know what the problem is?
Yeah.
This is Commissioner Malema's problem. You can never succeed in a claim for damages where negligence is contested until negligence is established. Now, you are not saying anything about negligence. He is asking you, is it not a miscarriage of justice to find for a party in circumstances where negligence, which is a key requirement in that finding, has not been established? Now, if parties have to come back to court because of the judge's mistake, who should pay? Why should the parties pay? Why should the road accident fund pay? Because of the judge's mistake. In circumstances where judges are even entitled to confer with senior judges and say, I've got a problem here. What are the requirements? Without deciding the matter for me, just have a look. Have I covered everything? Something like that. Seeking guidance, seeking to be mentored. That's what he's concerned about. Who should pay?
I should live with this mistake, but in living with this mistake, I do inquire, I do seek help when it is just one of those issues that I have to live with this mistake, unfortunately, and I accept the responsibility for that. But in the normal course of my duties, I do seek advice and help.
Now, ma'am, maybe let's move forward. We'll deal with that in our deliberations. Can you just give us a brief lecture on PAJA again?
All right. What about PAJA? What is PAJA? PAJA was enacted in order to put effect to the Section 33 of the Constitution. Because Section 33 of the Constitution provides that there must be the decisions that are taken by functionaries must be reasonable, fair, and just, all those. But then PAJA was enacted to be the vehicle used in that regard to make it practical for people who are not happy by the decisions that have been taken or by the decisions that have not been taken by that functionary, which are prejudice to them or which affects the constitutionality of their constitutional rights.
You didn't see any need to, okay, maybe let me put it differently. Did you prepare for this interview?
Yes, I did.
In the preparation of this interview, you didn't see any need to refer to your performance, your previous interviews, the type of questions asked, so that you don't commit similar mistakes?
As I have already indicated, Mr. Commissioner, you know, my interview was not good at all. The last interview was not good, and
I'm worried we're committing the same mistakes. Because if you had referred to the previous interview in preparation, it's ordinarily, perhaps it's supposed to be like that. I went there, I'm going for the second time. The likelihood is that I'm going to be asked the same things like we're doing now. You don't refer to the previous one so that you don't commit a similar mistake, because you take this body very serious. But it looks like we have not done that.
I do take this body very, very seriously. And I would like you to repeat your question about what I said, because there's no way that I cannot take this body and take it for granted. Definitely.
Thank you very much, Chair.
Thank you. Commissioner Nsebeza?
Just one question, President. Advocate Cossie, the Chief Justice was commented on your having been part of the Tongwane and others case. Is that the case that originated in the North Gauteng High Court?
Yes.
At what level were you involved, and for which party were you involved? Did you, for instance, were you involved in the Constitutional Court when this matter was dealt with there?
Unfortunately, I did not at that stage because I was acting at that time.
At what level were you engaged?
I was engaged, I was representing the Department of Land Affairs. I was working with Mr. Dokota SC in that regard.
Where?
In Pretoria.
Yes. Because I see that in the list of council who are involved in the Concord, your name does not appear.
Yes, I did not go to the Concord.
Dogota's name also doesn't appear.
He was briefed. I was working with him there.
Yeah, no, I'm saying in the Concord.
All right.
His name doesn't appear for any of the parties. For the applicants, it was Trengove, Badlander, Dodson, Sikakane, Lockwood, and Cowan, all instructed by the Legal Resources Center. And then for the State Attorney Pretoria, it was Kasim SC and Mokaditwa. And then Stole SC and MC Baloi, instructed by the State Attorney Pretoria for the other cabinets. And then Denzel Potgieter, instructed by the State Attorney Cape Town. So
I wouldn't know, Mr. Nsebeza, because by then I was not involved in that matter. Yes.
Okay.
Well,
Thank
then
you, Chair.
why do you cite the Constitutional Court part of it? As if it's one of the cases that you were involved in up to Constitutional Court level.
The citation is what is there, but I was involved in all the proceedings, but I did not go to the Constitutional Court. But that is the citation, Chief Justice.
No. I want to be fair to you, and I don't want your answer to be misunderstood and possibly to your disadvantage. When you cite cases, it is those in which you were involved in court, either as an attorney or as an advocate. If you were only involved at high court level, you don't cite the Supreme Court of Appeal, you don't cite the Constitutional Court, because you were not there. It shouldn't count in your favor. Did you not understand, or what was why did you cite the Constitutional Court one? Because I specifically said, I see that you were involved in this important case of Tongwane, which was handled by the Constitutional Court. And you said, yes.
Yes, I was involved, CJ, but not at the Constitutional Court. I did not go to the Constitutional Court because I was not available at that time.
Thank you, ma'am. You're excused. Thank you.